I want to announce that the Federalist Society annual dinner will from now on be the Antonin Scalia Memorial Dinner. And to introduce our guest speaker tonight, I'm going to call up Justice Scalia's son, Eugene, who is formerly Solicitor of Labor and who currently works at Gibson Dunn Crutcher. Eugene?
Gene, thank you, and I'd like to thank you, the Federalist Society, and so many of you in the room tonight for all you've done these past months to honor my father's legacy and to support his family. I'd like to express special thanks to Leonard Leo. My father would be deeply touched by this tribute at the conference this week and by the naming of this dinner after him. The affection that you all have shown him was reciprocated. My father was proud of the Federalist Society. He manifested this pride occasionally by claiming that he actually had established the Federalist Society and was responsible for its existence, or at least that he deserved partial credit. He was proud to have supported David McIntosh in founding the Chicago Law School chapter, and he was pleased that his earliest clerks included Lee Otis, Gary Lawson, and Steve Calabresi. "25 years ago, my father gained another friend, a great friend, and an ally who would support him and occasionally challenge him for a quarter of a century. It is impossible to fully appreciate my father's tenure on the court and his legacy without understanding his historic collaboration with Justice Thomas. What many consider to be my father's greatest opinion, his dissent in Morrison v. Olson, did not impress his colleagues at the time. It did not get another vote. What a different court it became 3 years later, when my father gained a colleague who shared his interest in originalism and in the Constitution's structure and its checks on government power. And how much we all have benefited from the fact that while he shared these interests with my father, Justice Thomas also did identify areas of disagreement where he questioned and he pushed my father. He pushed him on stare decisis and on what my father playfully called his faint-hearted originalism. And he pushed Justice Scalia in that area that was my father's greatest passion, administrative law, engaging him in a debate about the roles of courts and the executive in the interpretation of law that continues today and that is a debate of incalculable importance. In Justice Thomas, my father found a colleague who for a quarter century, as Justice Thomas would say, I think, had his back in doing his job as the Constitution required so they could, as they both would say, get it right. And he had a colleague who deepened his thinking, and all of ours, about the court and its role in our society. Equally important, actually, to me as a son, maybe more important, in Justice Thomas, my father found a true friend, someone who shared his laughter and his deep, steadfast loyalty, a man of incredible warmth, decency, and wisdom, someone who simply was there to cheer my father and brighten his days for his last 25 years. And I'll just add, who's been a great comfort to my mother and my family, including my own children, in these past months. We are all fortunate to have Justice Thomas on the court. We're equally fortunate to have him as our friend. Justice Thomas.
Thank you. Thank you. Thank you all. Thank you. Thank you all. Gene, thank you for that amazing introduction. Makes me want to quit while I'm ahead. I may take a moment of personal liberty here and first of all just recognize my dear friend Maureen Scalia and the entire Scalia family. Would you all rise so we can... I'd also like to point out that my bride is here, Virginia. And we seem to travel like nuns. We travel in pairs here. I have been very, very fortunate. I've seen many of my friends here. Quite a few of my former law clerks and my adopted law clerks are here. I have no idea how many. Would you please stand so I can at least see who you are? Wow. Well, that's pretty humbling. Thank you all. This is an unbelievable crowd. This is an amazing conference or convention and an amazing dinner. That was a very touching video. It certainly got to me. I'm sitting here pondering, why is this spoon and this fork up here? It's amazing the things that distract you, you know? Before I go on, I'd like to just also say good evening to Martha Ann Alito and my colleague, Sam Alito, who are here. I'm not running for office. These are important people in my life. And you know, starting with that beautiful film and so much of what is going on here, much has been said about my friend Justice Scalia since his untimely and very sad passing this February. And much more will be said during this convention appropriately dedicated to his legacy. Though much may be said about him, little needs to be said for him. His opinions, books, articles, speeches, lectures, and countless other exchanges of ideas leave his voice forever with us. Many of you may recall, but not so fondly, the heady days of the 1970s, when the emphasis in constitutional law was on rights. There was also a focus on the use of judicial power. In those days, we began the study of law with Marbury versus Madison. The Constitution, though it was set out at the beginning of our case books, was but an afterthought, rarely to be consulted or disturbed. This state of affairs did not sit well with Justice Scalia. He traveled far and wide, challenging students and all who would listen, and I can hear his voice. What do you think is the reason that America is such a free country? If you think that a Bill of Rights is what sets us apart, you're crazy. Every banana republic in the world, every president for life has a Bill of Rights. the Bill of Rights for the former evil empire, the Union of Soviet Socialist Republics, was much better than ours. He would then make his point. Without the structural constraints that the Constitution places on government power, the Bill of Rights is just words on paper, or in a more originalist vein, merely a parchment guarantee. Limits on judicial power were of special concern to Justice Scalia. This concern informed his approach to statutory construction and constitutional interpretation. Our role as judges was to be confined to the words of those who drafted the Constitution or enacted the law in question, and what those words meant to the people when they were drafted. In short, the original meaning. We as judges do not get to freelance or put our personal gloss on these laws. Even in areas in which others might just tune out from boredom, such as jurisdiction, standing, or ripeness, Justice Scalia was ever vigilant, guarding against judicial power being exercised where judges had no authority, thus encroaching on the authority of other branches or the states. One sees this abiding concern in Justice Scalia's commitment to the canons of statutory construction. Who else would labor so diligently and exhaustively on a book on the 57 canons of construction? As an aside, I watched on a number of occasions as he dragged himself out of his office after laboring over his court work, only to work endless hours on his book, reading law. As complicated and intricate as these canons may sound, they all serve a single purpose: uphold the structural constraints of the Constitution in order to protect our liberties. We as judges employ the canons to discern the commonly understood meaning of the words chosen by Congress. We do not resort to our own predilections to divine what Congress might have intended. As hard as he worked, he seemed to savor every chance he had to argue for an approach that enhances liberty and restrains the exercise of government power. Along the way, he seemed to relish doing his work, sprinkling it with humor and his wonderful flair for prose. Though the work was monumentally serious, he just seemed to have fun doing it. And how well he did it. I can't resist citing a few of his memorable quips. When he drafted a particularly good one, he loved to give me a dramatic reading. Brother Clarence, you have to hear this one. Then, a not-so-quick computer search took place until the handiwork appeared. While a judge on the D.C. Circuit in a statutory interpretation case about labeling requirements for meat products of all things, he quoted Bismarck to warn us that, quote, "No man should see how laws or sausages are made." Later, in Lamb's Chapel, he famously described the court's lemon test for the Constitution's Establishment Clause as, and I quote, "some ghoul in a night horror movie that repeatedly sits up in its grave and shuffles abroad about being repeatedly killed, after being repeatedly killed and buried." I could say, ooh. He always did that when he read it. It talks about our Establishment Clause jurisprudence once again frightening the little children and the school attorneys of Senator Marici's Union Free School District. Ooh. I don't know where that came from, but he always did. To register his disagreement about the constitutionality of abortion buffer zones in Hill v. Colorado, Justice Scalia said that if forbidding peaceful, non-threatening, but uninvited speech from a distance closer than 8 feet is a narrowly tailored means of preventing the obstruction of entrance to medical facilities, the governmental interest estate asserts, narrow tailoring must refer not to the standards of Versace, but to those of Omar the tent maker. I have no idea where he gets these things. Likewise, in Maryland v. King, he rejected the court's decision that swabbing the cheeks of arrestees was a constitutional search. In his words, and I quote, "I doubt that the proud men who wrote the Charter of our liberties would have been so eager to open their mouths for royal inspection." And in Lee versus Weissman, Justice Scalia lamented, "I find it a sufficient embarrassment that our Establishment Clause jurisprudence regarding holiday displays has come to require scrutiny more commonly associated with interior decorators than with the judiciary. But at least," he went on, "interior decorating is a rock-hard science compared to the psychology practiced by amateurs to decide whether a prayer during a graduation ceremony was too coercive for high school students." To be sure, he would be biting at times. Of the court's opinion in National Endowment for the Arts versus Finley, he said, "The operation was a success, but the patient died. What such a procedure is to medicine, the court's opinion in this case is to law." And Scalia the critic did not discriminate. Of my majority opinion in Navarrete, by the way, I did not get a dramatic reading of this one. Of my majority opinion in Navarrete versus California, a case involving the constitutionality of a search of a suspected drunk driver based on an anonymous tip, he wrote, and I quote, "The court's opinion serves us a freedom-destroying cocktail." I have no idea where he got that. He blamed his law clerks, but I have better ideas. Justice Scalia also asked the big questions that have long perplexed philosophers and judges alike. Questions like, what is golf? In PGA Tour versus Martin, he wrote, "I am sure that the framers of the Constitution, aware of the 1457 edict of King James II of Scotland, prohibiting golf because it interfered with the practice of archery, fully expected that sooner or later, the paths of golf and government, the law and the links, would once again cross, and that the judges of this august court would someday have to wrestle with the age-old jurisprudential question for which their years of study in the law have so well prepared them. Is someone riding around a golf course from shot to shot really a golfer?" In one campaign finance case, he reminded us of the timeless truism that campaign promises are, by long democratic tradition, the least binding form of human commitment. And in another, that we American people are neither sheep nor fools when it comes to campaign speech. And we will not soon forget Justice Scalia's rebuke of legislative history in Chisholm versus Romer. There, the court reasoned that the absence of legislative history could be likened to the dog that did not bark, Justice Scalia responded, and I quote, "Apart from the questionable wisdom of assuming that dogs will bark when something important is happening, we have forcefully and explicitly rejected the Conan Doyle approach to statutory construction in the past. In ascertaining the meaning of a statute, a court cannot, in the manner of Sherlock Holmes, pursue the theory of the dog that did not bark. We are here to apply the statute, not the legislative history, and certainly not the absence of legislative history. Statutes are the law, though sleeping dogs lie." For decades, in cases big and small, Justice Scalia delighted us with his command of the English language, his rapier-like prose, and often side-splitting humor. But tonight, I charge us with the following responsibility: that these words, spoken and written by Justice Scalia, not be the final words in support of originalism and constitutionalism. Rather, they ought to be a prologue. 153 years ago, almost to the day, President Lincoln said at Gettysburg, "The world will little note nor long remember what we say here. It is for us, the living, rather to be dedicated here to the unfinished work which they who fought here have thus far so nobly advanced, that we take increased devotion to that cause for which they gave the last full measure of devotion, and that government of the people, by the people, for the people, shall not perish from the earth." Justice Scalia has done his part to preserve our liberties and to properly interpret our laws and our Constitution, so that this government of the people shall not perish. His life's work is now ours to finish. At the risk of being repetitive, but with the hope of clearly establishing a point, Justice Scalia's project was simple. If we adhere to the structure of government prescribed by our Constitution, we protect liberty and freedom. The limitations on legislative power in Article 1, the limitations on executive power in Article 2, and the limitations on the judicial power in Article 3. Those are our constitutional safeguards. Those protect our liberty and our freedom. Madison put it best in Federalist 51. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the governed, and in the next place, oblige it to control itself. Justice Scalia's daily task, as he saw it, was to oblige the government to control itself and to convince Americans to implore their government to do the same. Only with limited government is our liberty secure. For Justice Scalia, the Constitution is a prescribed structure, a framework for the conduct of government. In designing that structure, the framers themselves considered how much commingling of the branches was acceptable and set forth their conclusions in the document. The Constitution answers this most important question: who will decide? The Congress, the President, the courts, the states, the people. And when the branches of government dare to tinker with the Constitution's answer to that most important question, the question of who will decide, Justice Scalia's wrath was sure to come down upon them. Perhaps Justice Scalia's project, requiring more than mere parchment barriers between the branches of government, seems academic to some. but it is anything but academic. As Justice Scalia acknowledged in his oft-quoted Morrison versus Olson dissent, and I quote, "The separation of powers may prevent us from righting every wrong, but it does so in order to ensure that we do not lose liberty." Without this separation of powers, the picture Alexander Hamilton painted of an all-powerful Congress, quote, "the hideous monster whose devouring jaws spare neither sex nor age, nor high nor low, nor sacred nor profane," becomes a reality. That hideous monster devours the reserve power of the states. It devours our freedom and our most innate desire to be let alone. With unchecked congressional power, Congress can commandeer the states to do the work of the federal government that it cannot do, as Justice Scalia wrote for the court in Prince versus the United States. With unchecked congressional power, Congress can shirk its legislative duties and avoid political accountability by delegating legislative power to a group of outsiders. As Justice Scalia humorously stated in Mistretta versus United States, what results is a sort of junior varsity Congress, incompatible with our constitutional structure. Without the separation of powers, the branches take it upon themselves to determine just how much of the purely executive powers of government must be within the full control of the president. In Morrison versus Olson, the wolf came as a wolf, according to Justice Scalia, when Congress appropriated executive power for itself and created the Office of Independent Counsel. Without the separation of powers, the executive branch no less co-opts the legislative power for itself. With unchecked executive power, federal agencies are emboldened to legislate without limitations in the nearly 180,000 pages of the Code of Federal Regulations. Judicial deference to agency decision-making becomes a rubber stamp for agencies to do as they please, and they can freely pretend that Congress hides elephants in mouse holes, in Justice Scalia's words, when Congress directs them to act. Finally, without the separation of powers, the judicial power is unrecognizable. As the political branches aggrandize power, so too do the courts. Today, it is the view of many that the Supreme Court is the giver of liberties. What an odd conception of government, that we, the people, are dependent upon the third branch of government to grant us our freedom. It is this last point for which we remember Justice Scalia so well. The court, as he said in Sosa Alvarez Machine, at times seems incapable of admitting that some matters, any matters, are none of its business. And from his dissent in Obergefell versus Hodges, and I quote, "Today's decision says that my ruler and the ruler of 320 million Americans, coast to coast, is a majority of the 9 lawyers on the Supreme Court. The opinion in these cases is the furthest extension in fact, and the furthest extension one can even imagine of the court's claimed power to create liberties that the Constitution and its amendments neglect to mention. This practice of constitutional revision by an unelected committee of 9, always accompanied, as it is today, by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, the freedom to govern themselves. With such unchecked judicial power, we Americans leave it for the least accountable branch to decide how existing rights should expand our contract, should expand or contract, a decision that so often hinges upon which particular rights are judicially favored at the time and which are not. With such unchecked judicial power, we leave it for the least accountable branch to decide what newly discovered fundamental rights should be appended to our Constitution. Of course, as Justice Scalia remarked in Cruzan versus Missouri Department of Health, these newly discovered fundamental rights are neither set forth in the Constitution nor known to the 9 justices of our court any better than they are known to 9 people picked at random from the Kansas City telephone directory. And I add, I'd rather bet on the folks in Kansas City or perhaps 9 truckers at a Flying J truck stop. With such unchecked judicial power, the court day by day, case by case, is busy designing a constitution, as Justice Scalia once quipped, instead of interpreting it. In any ordinary year, Justice Scalia would have spent the summer teaching these lessons about the separation of powers to a group of students studying abroad. And by this time, he would be back hard at work on a biting but always insightful and entertaining opinion, imploring the branches of government to respect their constitutional roles and their limits. But alas, this has been no ordinary year. This summer, I had the distinct but sad pleasure of filling in for my dear friend in his separation of powers course in Nice, France. And my colleagues and I, very sadly, have begun this term without him. When I joined the court in 1991, Nino Scalia and I would have seemed an unusual pair, an odd couple. He, raised in Queens and the son of an Italian immigrant and a first-generation American, one a professor of Romance languages and the other a school teacher. And I, raised a decade later by my barely literate grandparents in Savannah, Georgia. But together, we soon became our own band of brothers. By 1991, Justice Scalia's role on the court was well established. I merely joined the fray, or more accurately, was thrown into it. It was my great honor that we spent almost 25 years together in pursuit of this common goal, to preserve the structure of government crafted by our framers. What I will treasure most, though, is much simpler. The chance to spend so many years down the hall from my friend Nino. Whether he was with me or against me in a particular case, we did what we thought the Constitution obliged us to do. We honored our oaths, and we trusted each other. Tonight, I charge each of you to join this band of brothers. As Shakespeare's King Henry implored, preparing his own troops for a seemingly hopeless battle against the French, the good man shall teach his son the story of our fight, and in it shall be remembered, we few, we happy few, we band of brothers. For he today that sheds his blood with me shall be my brother, and gentlemen in England now abed shall think themselves accursed they were not here, and hold their manhoods cheap, whiles any speaks that fought with us upon St. Crispin's Day. Each of us here, men and women, young and older, need not think ourselves accursed, for our St. Crispin's Day lies before us. And whether we in this room tonight ultimately win or lose the effort to reclaim the forms of government that the framers intended, it is our duty, to stand firm in the defense of the constitutional principles and structure that secure our liberty. Like Justice Scalia, we must do what the Constitution obliges us to do. It is now for us, the living, to be dedicated to the unfinished business for which Justice Scalia gave his last full measure of devotion. Thank you all.
Thank you. Thank you, Justice Thomas. I have two things. First, let me apologize for the silverware. I'll find a better implement to quiet the crowd. But second, and more important, we at the Federalist Society wanted, there's not much you can give a justice of the Supreme Court, but we wanted to give you a small token of how much we appreciate you and how much we will honor your call tonight to once more enter the breach. It's a photo of you and Justice Scalia